It was prior.
And are you a certified peace officer in the state of Ohio?
I am.
Okay. How long have you been certified?
9.5 years.
Can you tell me what it means? I mean, when we say certified peace officer in the state of Ohio, what does that actually mean? What did you have to do in order to get a certification to be a police officer?
I had to go to the police academy, and each year we do continuing education.
What kind of education do you have to do each year?
We do the domestic violence, and there's mandatory courses that we have to do each year.
And have you been up to date, kept up to date with that training?
Yes.
And when you work with each police department, did you have to have like a field training officer during a period of time working there?
Yes.
Okay. What does that mean to have a field training officer?
So field training officer, you have to meet standards and patrol the area and meet their expectations for the department.
Okay. And so somebody actually like supervises you and watches over what you're doing for a period of time when you start with that department?
Yes.
Through the course of your work as a police officer, have you had occasion to become involved in investigating and responding to domestic violence calls?
Yes.
Approximately how many times in your career?
I would say at least one domestic per month, at
Through
least.
the course of the entire time you've been?
Yeah, at least, I would say.
Okay. What about strangulation cases? How often have you responded to those?
Say approximately no more than 10.
So a little less than the domestic cases normally.
Yes.
And in investigating and responding to domestic cases, domestic violence cases, do you always see injury when you respond and investigate?
No.
Okay. And can you explain why that is?
Well, domestic can also be through threats, or there's not always, apparent injuries right away.
And have you ever had any domestic cases that you've responded to where perhaps someone has admitted that they struck someone, but there's no actual visible injury?
Yes.
Okay, and just because there's no visible injury, does that mean that there's not an injury?
No, doesn't mean that.
Now, looking at this particular case and directing you back to January 1st of this year, were you working on that day?
Yes.
Okay, what shift and hours would you have been working?
Midnight shift, it's 7 p.m. to 7 a.m.
And it's New Year's Day, so was that a busy day for you all?
That was a very busy day.
And when we're talking about the early morning hours of New Year's Day, and you were working, were you in a specific zone that day?
I was.
Where would you have been working?
I don't recall. That was a busy day.
And through your work that day, what would you do in the city of Painesville?
My duties would have been to respond to calls, patrol, and investigate traffic and criminal cases that we got.
During the course of your work that day, did you have an occasion to respond to the Hollydale apartments?
Yes.
And approximately what time, if you recall, was that?
I don't recall off the top of my head.
Okay. Was it early morning hours, late in the day?
It was past midnight, I believe.
Past midnight. Okay. Was it dark out or light out?
It was dark out.
Okay. And do you remember what the weather was like?
I believe it was light rain.
And when you responded there, were you the only officer that responded to Hollydale Apartments?
No.
Okay. Who else responded there?
Myself, I had a trainee, Officer Flanagan, Officer Bowski, Officer Grove, and Officer Federico.
So were you the first on scene?
No.
Who did you know was the first on scene?
Officer Bowski and Officer Federico got called to that call.
And did you then ultimately respond as well?
Yes.
Okay, with your trainee?
Yes.
Okay. And what was the nature of the call? Why were you all responding there?
It was a call, it was a text to 911. Then our dispatcher had called back, and I checked on the female, asking if she was okay, and she said no, and then hung up.
And that's basically the extent of what you knew at that point in time?
Yes.
Had you been given any other information by any of the other officers prior to your arrival?
No.
Okay. When you arrived, then what did you do?
Once I arrived, There was a female in the hallway who I know is Faith Confer. Then walked outside the apartment. Mark Jackson, met with him and spoke with both of them.
Now, when you're responding to this, the Hollydale Apartments, where specifically is that?
Hollydale Apartments is north side of town. It's 908 North State Street.
Are there a number of different apartment buildings there?
Yes,
And which building were you responding to?
building number 4.
And do you know what apartment you were responding to?
Off the top of my head, I do not.
When you got there, you said that you saw Faith Confer.
Yes.
What did you notice about her, if anything, when you saw her?
It was apparent that something had happened. Her eyes were red, and from my priors with Faith, she's usually outspoken, and she was kind of quiet and seemed timid.
And was there anything that you noted about her voice at all?
It was, I want to say, scratchy. Like she had a sore throat.
And when you had spoken to her before, did it sound like that?
No.
And when you say she was timid, did you normally, in your interactions with Faith, would you have called her timid?
No.
Okay, and so was this a different Faith Confer than you were normally encountering?
Yes.
When you had an opportunity to speak with her, what specifically did you do when you got there and you saw her?
When I spoke to her, I asked her what had happened. She explained that.
Objection. Overruled.
She explained that there was a physical altercation with her live-in boyfriend, and they also have a child together.
When she's talking to you about that, what was her demeanor?
Again, it was kind of timid, and I'm kind of shaken up as something had happened.
And at that point in time, did you really know what had happened?
No.
And when you first arrived on scene, did she recognize you and talk to you immediately when you got there?
Yes, yeah.
And when she's telling you what happened, was it a response to a lot of questions, or did you just simply say what happened?
It was what had happened and some follow-up questions.
And she said she got into a physical altercation with her boyfriend. You knew that to be Mark Jackson?
Yes.
What specifically had happened?
She demonstrated that Mark had crossed his arms into an X and had applied pressure on her throat area.
While she was standing up, sitting down?
When she was in a bed.
Okay. So did she tell you what the argument was about?
Yes.
What was it about?
She advised it was over a phone, over Mark's phone.
And when she was talking to you about this, was there any indication whatsoever that she had any physical contact directly with, meaning did she hit, slap, do anything to Mark?
No.
And what did she indicate that the physical portion of this was then after he crossed his arms and you said placed it on her neck?
Yes.
She demonstrated that to you?
Yes.
And did she tell you what happened as a result of that?
She advised that she couldn't breathe.
And did she tell you how long this had happened?
I don't recall that.
Was anybody else in the apartment while this was going on?
Yes, they have I don't know how old the child is, but a small baby.
Where was the baby when this happened?
In the bedroom.
In the same bedroom where this happened?
Yes.
Okay, when you say it happened in the bedroom, did she explain to you what specifically happened? Or did she just tell you that it happened in the bedroom?
She just advised it happened in the bedroom.
Okay. And did she give you any more details other than he crossed his arms like an X and put it on her throat and she couldn't breathe?
I don't recall.
How long did you stay there and speak with her?
Approximately an hour.
Okay. And throughout the course of the entire hour that you all were talking to her, did her demeanor change at all?
She still seemed timid and not as outspoken as she normally is.
And did she seem upset at all?
Yes.
What about her made you think she was upset?
It seemed like she was crying prior to us getting there.
time did you hear her speaking to other officers about what had happened?
She was speaking with the other officers, yes.
And when she's speaking to the other officers, was what she was telling them consistent with what she had told you?
Yes,
Do you know whether or not she wrote a written statement?
she did.
And did you have an opportunity to look at that written statement?
I didn't have the chance to, no.
Okay. And when she's writing the written statement, were you all kind of hovering over her saying, no, put this in there, put this in there, put this in there?
No,
Okay. Was she kind of on her own able to write?
yes.
And how long did it take for her to write that statement?
I don't recall.
When she demonstrated what had happened with Mark crossing his arms and putting him on her neck, how long did she say she couldn't breathe for, if you recall?
I don't recall. She just told me she couldn't breathe.
She couldn't breathe, right? And did you know why, did she explain to you at all why her voice was so scratchy?
Over Mark putting his arms on her throat, around her neck.
You might just have a moment, Your Honor. Something further, thank you, Your Honor.
Cross-examination?
Good morning, officer.
Good morning.
So on direct officer, you referenced some of your training and experience, correct?
Correct.
And some of that training and experience includes training to testify.
Correct.
And officer, on January 1st, you observed both Mark Jackson and Faith Comfort, correct?
Yes.
And you did not observe injuries to either party.
No, I did not.
For example, on Faith's neck, you did not observe bruises, scratches, etc.
No.
And on Mr. Jackson's hands or arms, you did not observe any sort of scratches, bruises, cuts, correct?
Correct.
And officer, would you agree that you spent time in contact with Mark Jackson as well as in contact with Ms. Comfort that night?
Can you repeat the question?
Yes, officer. Would you agree you spent time in contact with Mark Jackson as well as with Faith Comfort on January 1st?
Yes, I had contact with both.
Okay. And specifically, you had questioned Mr. Jackson about what had occurred?
Yes.
Your Honor, may we approach?
Yep.
Thank you, Your Honor.
And Officer Witt, while you were questioning Mark Jackson, he spoke to you freely, correct?
Correct.
He was not combative with you at all?
No, he was not.
He didn't do anything violent at all?
So, are you asking to the officers or?
To the officers, to Ms. Comfort while you were speaking with him?
No, not while we were there.
Okay. And one of your main goals was to determine whether or not he would confess, correct?
Our goal,
I didn't hear the question.
One of your main goals, officer, was to see whether or not he would confess, correct?
Did you say confess?
Yes.
Okay. Overruled.
To confess, we were investigating a crime to see what happened.
Okay, so you had no interest in whether or not he would confess to a crime?
I don't know if I'm understanding your question.
I'm gonna object again, Your Honor.
Overruled. You've asked him twice, he said, he answered the first time. You asked him again, he indicated he didn't understand the question, so proceed from there.
Okay, I can move on, Your Honor. And Officer Witt, you mentioned as well on direct about when you spoke with Ms. Confer, her voice you perceived it to be scratchy, correct?
Correct.
Again, there's a number of different reasons someone's voice could be scratchy, correct?
There could be, yes.
For example, if somebody had been shouting,
Correct.
if somebody was upset or shaken up, that could certainly be a factor, correct?
That could be.
And that was a factor you and all other officers considered that night, correct?
Correct.
And Officer Witt, were you present when Mr. Jackson was taken into custody that night?
Yes.
And again, he went with officers compliantly,
Yes.
again, without yelling or fighting.
Correct.
Do you recall if he was holding a baby when he was taken into custody?
I do. He was holding the baby and he gave the baby over to Faith. But then he was placed in handcuffs, placed under arrest.
Okay, and when he was giving the baby to Faith, he didn't yell at her in any way?
No.
He didn't do anything violent towards her in any way?
No.
He gave her the baby and he went with you?
Correct.
Okay. May I have one moment, Your Honor?
Yep.
No further questions, thank you.
Any redirect?
Yes, Your Honor, thank you. Officer Witt, when the defendant was taken into custody, how many officers were there?
There was myself, Officer Flanagan, Officer Grove, Officer Bowski, and Officer Federico. We were all there.
And based on that, all of you being there, you wouldn't have expected him to act in any way other than coming with you?
Correct.
The question was, there are all kinds of other reasons that your voice can be scratchy, but she specifically told you that it was because of what?
That she was choked by Mark Jackson.
And you were asked whether or not he was violent while you were there, and you kind of hesitated, and you said, well, not towards you guys. Was he violent towards somebody else prior to your arrival?
Yes.
Who was that?
That was Faith Confer.
And based on the way that Faith described the pressing down on her, the crossing his arms, putting them on her throat, would you have expected to see injuries to him?
No.
And have you had occasion to be involved again in domestic violence cases where you didn't see injuries to the victim either?
Correct.
Nothing further, thank you.
Any recross?
Yes, Your Honor. Now, Officer, just on redirect, you mentioned violence occurring, correct?
Correct.
Officer, when you reported to the scene, there was no violence ongoing,
While we were on scene,
correct?
there was no violence while we were on scene.
You were not a witness to any of this violence occurring, correct?
No.
Okay. And what, your account of what had occurred between Faith Confer and Mark Jackson is largely based on the accounts you've heard, correct?
The accounts of what we heard and other signs.
Okay. But primarily their testimony, right? Or not their testimony, but their statements, correct?
Her statements and what we observed on scene, her demeanor, and
Her demeanor, but no physical injuries that you witnessed no physical injuries, correct?
I didn't see any injuries on her, no.
Okay. Nothing further.
All right, you may step down, thank you.
All right, thank you, Your Honor.
Next witness?
Thank you, and State Hall Officer Alexander Grove to the stand. Maybe start by Your Honor.
Yeah. Raise your right hand, please. You swear to us when you're about to give us the truth, the whole truth, and nothing but the truth, so help you God.
I
Have a seat.
If you could introduce yourself to the jury, please, and spell your last name for the record.
I'm Alexander Grove. My last name is Grove.
Where are you employed?
Painesville City Police Department.
And how long have you been employed there?
A little over a year and a half.
Okay. Any other prior law enforcement experience?
No.
Tell me a little bit about what kind of training and education you had that qualified you to be a peace officer in the state of Ohio.
So I graduated from the Lakeland Police Academy, as well as CIT and a few other trainings.
What is CIT?
Critical incident training.
And what does that entail?
That entails dealing with people with mental health and helping them work through their problems.
And how long of training is that? Just like an hour or so?
It's a 40-hour class,
40 hour
so
class.
a week.
And you are a certified peace officer in the state of Ohio?
I am.
And how long have you been certified?
A little over a year and a half.
Through the course of your work with the Painesville Police Department, did you become involved and respond to a call at the Hollydale Apartments on January 1st of this year?
I did.
And do you recall what the nature of the call was?
I believe it was a 911 text, which led into a 911 hang-up.
And who did you respond there with?
Officer Bowski, Officer Witt, Officer Federico, and Officer Flanagan.
And do you recall what time of day it was?
I want to say it was about 2 o'clock in the morning.
And safe to say it was dark out?
It was.
When you responded there, were you in a marked car and in uniform?
I was.
And when you got there, what, if anything, did you observe?
I observed Officer Federico standing outside of his cruiser on the phone.
And then after you observed him, did you become involved or go in and speak to Faith Comfort at all?
I did.
And in speaking to Faith Comfort, you had not met her before, had you?
No.
And what, if anything, did you observe when you saw her?
She was very distraught. It appeared as if she was crying. She had red eyes, was very soft-spoken.
And at that point in time, you had no idea why?
No.
And who was she speaking to when you observed this?
She was speaking with Officer Bowski.
And after speaking with Officer Bowski, did you have an opportunity to spend some additional time with Faith?
I did.
Okay, and why was that?
Officer Bowski met with Officer Federico outside, and I stood by with Faith.
And what was the purpose of you staying there with Faith Comfort?
Just to make sure Mark didn't come outside or anything escalated.
And while you were there, I should say, how long did you remain on scene?
I would say probably about 45 minutes.
During the course of that, did you have occasion to observe Faith pretty much the entire time?
For the most part, yes.
And did her demeanor change at all while you were there?
No.
When you were talking with her, did you have an opportunity to see her or have her write a written statement?
I did.
Okay, and where were you when this happened?
We were in the landing just as you enter the doorway to the apartment building.
And why on the landing area? Why were you there?
I believe it was to separate the two parties.
I'm going to show you what's been previously marked as State's Exhibit 1G and 1H. May I approach, Your Honor?
Yep.
I'm going to show you Exhibit 1G and 1H. Just ask if you recognize those.
I do.
Okay, what am I looking at with 1G?
1G is where the apartment was, going up to the initial doorway when you enter the apartment building.
What about 1H?
1H was the landing where she was seated on the stairwell.
And so that second one is actually where you observed her,
Correct.
and she sat there?
Correct.
And how long did it take for her to write the statement?
I would say roughly 10 minutes.
Your Honor, for the record, just show him what's been marked. It's marked as State's Exhibit 6. Just going to ask of you to take a look at that first, and then when you're finished, let me know.
Okay.
Do you recognize what that is?
I do.
And what do you have in front of you?
That is the written statement from Faith Conifer saying that she wanted to pursue charges.
Okay, and what, if anything, how do you know that that's her statement?
I observed her writing it.
Are there any signatures on there that you are recognizing at all?
My own as well as Faith's.
And in her written statement, did you tell her what to say?
No.
How is it that she knew what to put in her written statement? What did you tell her?
I told her to talk about the incident, what happened, in as much detail as possible.
And when she was finished writing, did you tell her to go back and put additional information in there?
I believe maybe to expand upon certain things as names.
And that was the only statement that she wrote?
Correct.
And when she wrote that statement, was that consistent with what she told you too?
It was.
Was that consistent with what she told the other officers on scene?
It was.
And when you said you were asking her to put some more information in there, what was her demeanor when you were talking to her about that?
As she was filling it out, she was crying. I know she had to pause a few times to regain composure.
Okay. And Mark Jackson was not even out in that area when that happened?
No.
And when she was speaking to you, did she seem comfortable talking to you where she was?
Where she was? Yes.
Okay. And in other areas that she was, did you know whether or not she was comfortable talking in any other place?
I did not at the time.
Did you remain on scene then with Faith for most of the call?
I did.
And ultimately, you left and she stayed at the apartment with the baby?
Correct.
Nothing further, Your Honor, thank you.
Cross-examination?
Good morning, officer.
Good morning.
Officer Grove, you'd agree you were not the first officer who arrived on the scene, correct?
Correct.
For example, Officer Bowski was already talking to Ms. Comfort when you arrived.
Correct.
And some of your perception of what had happened was based on what you were told by other officers, correct?
Initially, yes.
Okay. And while on scene, did you have contact with both Faith Comfort and Mark Jackson,
Correct.
but primarily contact with Faith Comfort?
Correct.
And when you saw Faith, you observed no injuries?
I did not.
And again, you were on the scene for about 45 minutes,
Yes.
and you spent a considerable amount of time with Faith, correct?
Yes.
Going over her, or having her write the statement for you, correct?
Correct.
And again, you saw no cuts,
No.
no bruises,
No.
no scratches.
No.
And I know you mentioned the director, her eyes appeared to be red,
I did.
and she presumably had been crying,
Correct.
and again, her eyes did not appear to be bloodshot.
Not that I can recall.
Okay. Officer Grove, One of your duties as an officer investigating a scene is to look for physical evidence, correct?
Correct.
Another duty is to document physical evidence if you find it.
Correct.
For example, had the apartment been in disarray, things been knocked over, you would have documented that, right?
Correct.
You did not observe that.
Not in the bedroom, as I did not go in there.
And your understanding was that this alleged incident had taken place in the bedroom.
Correct.
And to your knowledge, no other officers observed the bedroom to be in disarray.
Not that I can recall.
In addition to no injuries on Ms. Confer, you observed no injuries on Mark Jackson's hands or arms, correct?
Not that I can recall.
Okay. Again, no scratches, bruises, anything of that nature.
Not that I can recall.
But had you observed them, you would have documented.
Correct.
And when you encountered Mark Jackson, officer, he wasn't yelling at anyone?
He was not.
He wasn't engaged in an altercation with Faith Confer at that time?
Not at the time.
Okay. And he wasn't belligerent with officers?
No.
And he went with officers freely, correct?
Correct.
And he willingly spoke with officers?
Correct.
Okay. One moment, Your Honor. No further questions, thank you.
And you redirect.
Yes, Your Honor, thank you. Officer Grove, you were not the first officer on scene, but when you were there, she was still distraught and crying.
She was.
So, how long had the other officers been there before your arrival, if you know?
Roughly 15 minutes.
Okay. And the question was asked about initially what you knew was from the other officers. Did you ultimately then learn additional information from anyone else?
I did.
Who was that?
Faith.
And in speaking to Faith, you didn't just rely on what the officers told you. She actually talked to you about what happened.
Correct.
What did she tell you?
She told me that
Overruled.
she was held down by Mark, as well as everything that was in the statement.
Okay, which would be what? What other kind of things did she tell you?
She said that it was over a phone, as well as the text messages on the phone, which is what started the initial altercation, as well as how she was held down and choked.
And did she describe that to you or show you anything?
She did.
Okay, what did she show you?
She showed me that she crossed her arms and pressed down on her upper chest area.
And she said that she was she able to breathe during this period of time?
She said she was not.
Was there anything else that she told you about what it was happening when she couldn't breathe?
She told me that all of his weight was on her. She wasn't able to move because Legend was next to her.
And so knowing what she told you and what other officers told you, did you expect the entire apartment to be in disarray?
From what I expected, yes.
You initially thought that there would be maybe more there, but did she explain to you specifically where this happened?
I believe she said in the bedroom.
Okay, and you didn't get a chance to go in the bedroom?
No.
Okay. You stayed out and talked to her?
For the most part, yes.
And when you all were there, how many officers were there?
5 in total, including me.
And did Faith tell you at any point in time that either of them were throwing things around the apartment or breaking things or doing anything like that?
Not that I can recall.
And did you hear her speaking to other officers about what had happened?
I don't believe so.
When she wrote the statement, was that consistent then with what she told you as in addition to what you learned from the other officers?
It was.
Nothing further, Your Honor.
Any recross?
No, Your Honor.
All right, you may step down, thank you. Next witness.
Thank you, Your Honor. State will call Officer Chad Bowski to the stand.
Raise your right hand, please. You swear a testimony about to give us the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Proceed.
If you could please introduce yourself to the jury and spell your last name for us, please.
I'm Officer Chad Bowski. Last name's Balausky.
Where are you employed?
Painesville City Police Department.
How long have you been there?
Been here approximately 5.5 years.
Any other prior law enforcement or military experience?
Prior to law enforcement, did about 2.5 years in North Perry and Timberlake.
And you're a certified peace officer in the state of Ohio?
Yes,
How long have you been certified?
about 8 years.
When I say you're a certified peace officer, what does that mean?
It means I completed approximately 640 hours of training at the police academy,
What police academy did you attend?
Cleveland Heights.
And following work or doing that training there, have you had any other on the job or any additional training since that time?
Yes, we do continuing education, online training every year. I have CIT training and am a SFST instructor.
Okay, what does CIT training mean?
It's a crisis intervention team. It's helping deal with people that are having mental disorders or in crisis, and that's a 40-hour course.
And what is SFSTS? What does that mean?
That's a standardized field sobriety instructor. That's the sobriety tests for OVIs.
And so that's some of the specific training you've had.
Yes,
Okay. And then through the course of your work as a police officer, have you responded to calls involving domestic violence?
I have.
And approximately how many times?
At least 50.
Okay. And during the course of responding to those, do you always see injuries in domestic disputes?
I do not.
And what about strangulation cases? Have you had an occasion to respond to those kinds of cases, strangulation or suffocation or choking?
Yes, I have.
Approximately how many times?
Very few. I would say maybe 2 or 3.
Okay. Did you have any specialized training in that area?
I do not.
Okay. On January 1st of 2025, did you respond to a domestic call?
Yes, I did.
Where did you respond?
It was Hollydale Apartments, 908 North State Street, Building 4, Apartment 107.
Approximately what time of day was it when you responded?
It was about 1:53 in the morning.
And New Year's Day,
Yes,
busy day?
very busy.
And on that day, how much time did you spend there on that particular call?
We were there for about 1 hour.
When you responded, what was the nature of the call? Why were you responding there?
It initially started as a text to 911 and then a 911 hang up.
Was that unusual to hear that, a 911 text?
Yes,
How many times in your career have you heard that?
that was the first time.
And did you know where you needed to respond?
Yes,
Okay, when you responded there, approximately how long did it take for you to get there from the initial call from dispatch?
it was about 5 minutes.
When you get there, where do you go specifically?
We went to the front door of Building 4.
And when you go to building 4, are you able to just get in?
Yes,
And you go directly to the apartment?
yes,
You're familiar with that area and those apartments?
yes, I am.
When you went in, and you went to the door, tell me what happened.
Opened the door, went down the stairs where the apartment is, and then knocked on the door.
And did anyone answer?
Initially, no.
And when you walk in the building, you're going down there, do you hear any commotion or anything like that?
Heard no commotion, just a little bit of talking going on inside the unit.
Okay. So initially, nobody responds. What do you do?
We ended up knocking again.
Okay, when you say we, who do you mean?
Officer Federico and I.
When you knocked again, what happened?
Faith answered the door.
And by faith, you mean who?
Faith Comfort.
When she opened the door, explain what you're observing when she opens the door.
She opened the door about halfway, just enough for her to stand in the doorway, and then she was very hesitant to talk with us.
Did you observe anything physically about her?
I observed her eyes to be red and watery, as if she was just crying.
Did you ask her anything?
We asked her if everything was okay.
And what did she say?
She said that she was just going through things.
Going through things, she didn't say she was okay, she didn't say she wasn't okay.
Correct.
And then what else did you observe her do?
She continuously would look to her left, and that which would be where the door was opening towards, and then slightly tilted her head that way.
Okay. Can you demonstrate what you mean by that?
She just kind of like looked like this and just slightly tilted her head.
Like tilted her head. And what did you take that to mean?
I took it as her hinting as if someone was standing behind the door.
So what did you do when you saw that?
I just looked towards the door and mouthed the words, "Is he standing there?" And she nodded her head yes.
So why was it that you didn't actually say anything out loud, you just mouthed the words?
Because I didn't know if someone was possibly standing there with a weapon or what they were doing behind the door.
Okay. Was that odd to you that somebody was standing right there behind the door?
Yes,
And the fact that this is a domestic call, did that raise any concerns for you?
it did.
Why?
Because I didn't know who was standing behind the door or if they had any type of weapon if there was someone behind the door.
Did you observe anyone or anything else in the apartment when you looked in?
I did not.
Okay. Do you know whether or not there was a dog there?
Yes, there was.
How did you know there was a dog there?
Because we heard barking when we knocked on the door.
Okay. When you hear barking when you knock on a door, does that cause any concern for police when they respond to a call?
Sometimes, depends on what type of dog might be inside.
Okay. And what did you do at that point in time? Did you continue to talk to Faith at the doorway?
No. Officer Federico asked her to step outside so the dog did not get out.
When she got outside the apartment, what happened then?
She closed the door behind her and began to speak with us.
And when she's speaking with you, was there anything that you noted about the way that she was speaking to you?
Yes, she was very soft-spoken, almost as if she was whispering, and her voice was very raspy.
Did you continue to talk to her right outside the door?
We did not,
Why not?
because we didn't know if someone was listening to us on the other side of the door, so we moved her to the landing right by the entrance.
When you're talking about her voice, did you know at that point in time whether or not that's the way her voice normally was, or if she was whispering so that he didn't hear?
We did not.
Okay, so at that point in time, you have no idea.
Correct.
And where do you go from the door?
We go up a set of stairs to a landing right near the entrance to the building.
And how far away from the apartment is that?
I'd say approximately 15 to 20 feet.
Why did you go there?
To separate her from someone that might have possibly still been inside so that they could not hear.
At that point in time, you had no idea.
Yes.
Okay. So when she's on the landing, did you have an opportunity to speak to her there?
Yes, I did.
How long did you talk to her?
I would say about 40 minutes.
And was that continuously?
Not continuously, no.
And why was that?
Because I was speaking with other officers would speak with her, and she ended up filling out a written statement.
Okay. So during the course of her speaking to other officers, were you able to listen to what she was saying?
Yes, I was.
And did you have an opportunity to see the written statement that she wrote?
Yes, I did.
And did she explain to you what happened as well?
Yes, she did.
During that course of that 40 minutes, did you observe her demeanor?
Yes.
I mean, can you explain what you observed throughout the course of that 40 minutes?
She would continuously either cry and then stop crying. Her eyes were red and watery the entire time, very soft-spoken throughout the duration of it, and her voice was raspy the whole time.
And did she explain to you why her voice was raspy?
Yes, she did.
What did she say?
She said it was because she was choked by Mark Jackson.
And that was her word.
Yes.
And she didn't use any other word other than that?
No, she did not.
Okay. When she said that, did she tell you how that happened?
Yes, she did.
How did she tell you that happened?
She said that she was pushed down onto her back on the bed. And then Mark got on top of her, made a cross with his arms like that, and then applied pressure to her throat area.
Okay. Now you were here when Faith testified before and talked about kind of the way things were. Was that the way she described it really to you when you were on scene?
The way that I described it or that she did?
The way when she was here testifying, is that the way she described it
The way that she described it to initially, slightly, but not completely.
And your understanding of the way and what she told you, told other officers on scene about what had happened when she did that, what happened to her when he made that cross and hit his full body weight across her neck?
She said that she was having trouble breathing.
And did she describe that to you?
She said she started seeing spots and just couldn't breathe anymore.
And was there any indication to you that there was any kind of major struggle or anything?
No, there was not.
Why? If you know.
Just, I didn't see any reddening on her neck, and she said she didn't have any injuries.
Okay. And where did this, was this alleged to have occurred?
In the bedroom, on the bed.
Okay, what kind of, or what size bed did they have?
It appeared to be a full, but based on her testimony, she said it was a queen.
Okay. And where was the baby, their baby, during this period of time?
It was on the bed to her right.
And when this is all going on, did she say she was able to move or roll away?
She said she was unable to move or roll away
Why?
because she did not want to knock the baby off of the bed.
Okay. Now, based on the way that Faith explained this happening to her, did you expect to see any major injuries or anything to her?
I did not.
And when you've responded to domestic calls before, do you always see injuries?
I do not.
Knowing that he put his full weight on top of her and kind of pushed down on her, would you have expected to see any kind of major injury to her?
No,
Did you know whether or not there were any internal injuries?
I did not.
And when you're listening to her, and she's talking to you, you're asking her about her voice, right?
Yes.
Does she say that her voice is normally like that?
She said it's not normally like that.
And she said that was because of what?
It said because she was choked.
And when you all arrive on scene there, were you dressed as you are today, or are you dressed a little differently?
I was dressed very similar to how I am today, but slightly different.
What would be different?
I had a external vest on with all my equipment and a duty belt on.
And do you have, or do any of the officers at the Hansville Police Department have body cam?
We do not have body cams.
Is there any kind of recording device or anything that you have when you do respond?
Yes, it's a wireless microphone that's attached to our dash cam.
And did you have that on this day?
Yes, I did.
And did each of the officers have that on that day?
Yes, they did.
Do those always give you real clear audio at all when you're listening to them?
It's not always the clearest, no.
And did you have an opportunity to listen to the dash cams in this case?
Yes, I did.
Whose was the clearest?
I would say either Officer Federico's or Officer Witt's was the clearest.
And did you have an opportunity to, and they were played in court here, but prior to even coming into court, listen to those, listen to the dash cam video?
Yes, I did.
And when Officer Federico testified, we played some snippets. Did those fairly and accurately depict what Faith said on that day?
Yes, it did.
And was that consistent with what she told you?
Yes, it is.
And who was your understanding that actually committed this offense, that was involved in this domestic strangulation with Faith Comfort?
It was her live-in boyfriend, Mark Jackson.
May I have a moment, Your Honor?
Yep.
Nothing further at this time, thank you, Your Honor.
Cross-examination.
Good morning, Officer Bowski.
Good morning.
Hear you the introduction. We're familiar with each other at this point. Now, on direct, the assistant prosecutor spoke with you a little bit about the training that you've received as a law enforcement officer, correct?
Yes.
Did any of your training include training as a first responder?
Yes.
So as a law enforcement officer, you are a first responder.
Yes.
So setting aside your criminal justice training for a moment, what are the limits of your training as a first responder?
To investigate crimes, render immediate aid if needed upon responding to that crime, and investigating traffic.
What aid have you been trained to provide?
Just basic first aid and CPR.
And, one moment, please. And what assessment would you conduct on an individual where you arrive and there's a potential that they might be injured?
Find out where the injury is, the extent of that injury, and render whatever aid I am able to render until emergency services get there.
And you have to make the determination whether or not to summon emergency services, is that correct?
Sometimes, yes.
In this particular case, did you at any point call EMS to the scene?
No.
And can you explain why?
She did not wish to seek any medical attention, and we did not observe any injuries on her.
Now, are there ever circumstances in your experience where you arrive at a scene, there is a likelihood of harm, and the potential injury exceeds your training?
Yes.
Under those circumstances, would you call for EMS even if the potentially injured party wasn't interested?
Yes.
Is that something that you did here?
No, it is not.
So you did not summon EMS in this event because Faith Comfort did not want EMS, correct?
Yes.
And also because you did not feel that it was warranted.
Yes.
You indicated that you in your training and in your experience have responded to approximately 50 domestic violence calls, correct?
Yes.
And you don't always see injuries there.
Correct.
You've responded to a few strangulation calls, correct?
Yes.
Have you ever responded to a strangulation call where you didn't see an injury?
Yes.
Can you describe the other things that you observed and have contributed to your experience on this topic that led you to conclude that strangulation occurred in those cases?
On this case specifically?
In your just outside experience, the 2 to 3 occasions that you've responded to strangulation calls, start of that, how many alleged victims or complaining witnesses did not have observable injuries?
Just one.
Just one?
Yes.
Did they have any physiological symptoms?
As in what?
As in loss of urinary continence, loss of bowel control, loss of consciousness?
No.
In your training as a first responder and in your experience as a law enforcement officer, have you developed a familiarity with how long it takes for somebody to start developing physical signs or physiological symptoms when a pressure is applied to their neck?
Yes.
Will you please explain to the jury what occurs within the first 30 seconds of somebody applying pressure with the firmness of a handshake to somebody's neck?
Come on up. All right, the objection's overruled. You can answer that question if you know.
It all depends on the individual and the other person as well.
Okay, but you've been trained on this topic, correct?
Slightly, yes.
Yes. So what might you expect to see, and therefore would you be looking for when you're investigating an allegation of strangulation?
Reddening on the neck area. No.
So when you investigate an allegation of strangulation, you're looking for redness on the neck, and there isn't anything else that you might expect to see?
Possibly bloodshot eyes.
Anything else?
Not to my knowledge, no.
And despite your limited training and experience with strangulation, you felt that EMS was not warranted here?
Correct.
You indicated that you might have concerns when responding to a domestic violence call, as you did here, when a complaining witness opens the door and you are unaware of where the alleged perpetrator might be.
Yes.
And that's part of scene safety as an officer, right?
Yes.
When you respond to a scene, your primary concern is scene safety. Everything else is secondary, correct?
Yes.
You had concern, reasonably, based on your training and experience, that there might be a weapon in the apartment, correct?
Yes.
Did you at any point locate a weapon in the apartment?
No, we did not.
Was there any indication that any weapon was used?
No.
Maybe when you arrived at the apartment, you were the first officer to get there, correct?
Yes.
And you and Officer Federico approached the apartment at approximately the same time, correct?
Yes.
As you approached the apartment, before you knocked on the door, what did you hear?
We heard people talking inside.
Were they talking in an animated fashion?
I do not recall.
Were they talking with heated voices?
I don't recall, no.
Prior to knocking on the door, did you hear a dog barking?
No.
Did you hear a baby crying?
No.
And when you got to the door, Ms. Comfort opened the door in a manner that you could only see her, correct?
Yes.
Describe for me the entryway to that apartment building. Strike that. Not the building, but to the individual apartment that you responded to.
To the door?
Yes.
Just a door that opens inward to the apartment. If you're facing the door, it'll open to the right.
And when the door is open, does it open directly onto a large open room?
It does not.
What does it open onto?
It opens up to a small hallway.
And in that hallway, you observed a number of items piled up against the wall, correct?
I do not recall.
In this trial, there were photos shown of that entry room to the apartment. You don't recall there being anything stacked against the wall?
I do not.
In a narrow entryway like that, is it typical for somebody to fling the door all the way open?
No.
With a hallway set up like that, particularly if two people were wondering who was on the other side of the door, it would be difficult to open the door all the way, correct?
Yes.
So you had concerns as to how she opened the door because you're a law enforcement officer and you have to. But upon further investigation, did the manner in which she opened the door make sense?
Slightly, yes.
Now, each of the cruisers that responded to the scene here was equipped with a dash camera, correct?
Yes.
And it's been described how these dash cameras work, as well as the fact that you carry a mic attached to your uniform away from the cruiser with you.
Yes.
And so that cruiser continues picking up video, which is largely just whatever is in front of it, but the audio continues to capture, correct?
Yes.
Did that occur in your case with your dash camera?
Not with mine.
What happened with your dash camera?
Mine was very staticky and a bunch of clicking noises.
Did you ever turn your mic on?
Yes.
When we watch a dash cam video, there are a number of words at the bottom of the screen, right? Mic, sirens, braking, I believe. Correct?
Yes.
And what happens when one of those activities is occurring?
I believe the light on the bottom lights up.
Or the letters, the that those words are written and turn green?
Possibly, I don't know.
You know if the mic ever turned green
I do not
when
know.
you were on your camera when you responded this day?
I do not know.
Do you know if we ever hear any discernible audio from your particular dash camera from this call?
It's very staticky. I couldn't make anything out.
Could that be because you never turned your mic on?
I believe my mic was on that.
But it's possible.
It was on.
Would it help if we refreshed your recollection?
Yes.
Come on up.
All right. Officer Bowski, when you arrive at a scene to do an investigation, which of your senses do you use?
All of them.
So you aren't just limited to what you're told, correct?
Correct.
While you're being told things, you make additional observation, correct?
Yes.
As to an individual's demeanor, which you've described here,
Yes.
as to the scene, the apartment itself.
Yes.
What observations did you make of this apartment?
That it appeared as any other apartment that I've went into in the city.
And when you proceeded to the bedroom, did anything stand out to you as to that scene?
I did not go in the bedroom.
In preparation for this trial, and while sitting through this trial, did you have opportunity to review photographs of the bedroom?
Yes.
And do you have any reason to believe that those photographs do not accurately portray the bedroom as it was seen that day?
I do not.
In reviewing those photographs, did anything stand out to you about the bedroom?
No.
Did anything stand out to you about the bed?
No.
You have one moment, Your Honor?
Yes.
No further questions at this time.
Any redirect?
Just briefly, Your Honor. Ms. Smith asked you some questions about physiological symptoms, things like there's the normal, the healthy operation of the body, there's certain responses that you have. Would you agree that, like a response to stress could just be having a, like, elevated heart rate, rapid heart rate?
Yes.
Not necessarily something that you're always going to see, and it can be different for every individual.
Yes.
Could that include having raspy voice and not being able to breathe if pressure is placed on your neck and throat?
Yes.
Now, we keep using the word strangulation, and I guess maybe we should kind of back up a little bit, so I want to ask you about this. Was it your understanding that this was what you would normally think of as being like hands around the neck, strangulation so you can't breathe?
No, it is not.
So how is this different?
Because pressure was applied to the throat area to restrict her breathing.
And so, in looking at it, did she talk about it having an issue with her normal breathing?
She did not.
Did she say that she was able to breathe normally?
During this incident, no, she did not.
But when she was talking to you, she appeared to be able to breathe normally after the fact,
Yes,
just not while it was happening?
correct.
And you had an opportunity to listen to the other dash cams that were involved in this case. Is that a fair statement?
Yes,
Were all of them real clear?
they were not.
When we're talking about having your dash cam, your car, how far away is your car situated from where you actually physically were?
I would say maybe 100 feet.
And so when you get to that point, is it harder and harder to hear the farther away you go?
Yes.
When you talk about clicking noises, do you know what that's from?
I believe it's from the interference of the distance between where I am in the cruiser and whatever physical interferences there may be, whether it's a wall, door, or other vehicles.
But you had an opportunity to listen to each of the dash cams, and what were there, like with Officer Federico's dash cam, was it much easier to hear on that one?
Yes,
Now, I know that we only played like small portions of what was said there. The statements that we heard and the things that she said, were those things repeated throughout the entire time they were there?
yes, they were.
Was there anything different or anything that we, other than kind of what we heard here, that you're aware of?
No,
So even though you're there for 45 minutes, y'all are talking to her for a while, are there some periods of silence too?
yes, there is.
So in going through this and not playing the whole thing, we still were able to hear the relevant parts of this?
Yes.
Nothing further, thank you, Your Honor.
Any recross?
Nothing based on that, Your Honor.
All right, you may step down, thank you. State have any other witnesses?
No, Your Honor.
State resting?
Yes, Your Honor, with pending admission of exhibits.
All right, ladies and gentlemen, the state has rested. That means they presented all the evidence they intend to present. We will move on to the next phase of the trial for the defense if they choose to put one on. But for right now, we've got some things to do out of your presence, so I'm going to give you a break. It's probably going to be about 20 minutes or so. Remember, not to discuss the case. Don't try to find out any extraneous information, and don't come to any conclusion until you begin deliberations.
All right, we're here.
All right, have a seat. All right, as to the exhibits, Ms. Linden?
Thank you, Your Honor. Your Honor, in looking at the exhibits, the state would be moving for the admission of States Exhibit 1A through I, 2, A, B, and C, 3A through K, Exhibit 4, Exhibit 7, 7A, 7B, or I'm sorry, 7A1, 7A2, 7A3, 7A4, A, B, C, and D. And that would be it at this point in time.
Okay. Any objection to those exhibits?
No objections, Your Honor.
All right, so states exhibits 1A through I, 2, A through C, 3, A through K, 4, And then 7A1 through 4 are admitted without objection. Ms. Smith?
My co-counsel will be making a Rule 29 on.
Mr. Kuklinski, go ahead.
Your Honor, Mr. Jackson moved the court for judgment of acquittal pursuant to Rule 29. Here, under Rule 29, the evidence is insufficient to sustain a conviction on either count. With respect to the standard, Rule 29 provides the court shall order an entry of judgment or acquittal on one or more of the offenses charged in the indictment, information, or complaint if the evidence is insufficient to sustain a conviction of such offense or offenses. State v. Jenks and State v. Bridgman further explicate or expound on that standard. State v. Jenks provides the relevant inquiries whether the after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime proven beyond a reasonable doubt. And State v. Bridgman provides that the motion for acquittal should not be granted when the evidence is such that reasonable minds could reach different conclusions as to whether each material element of a crime has been proven beyond a reasonable doubt. Conversely, if there's even a single element where no reasonable juror could find that element's been met beyond a reasonable doubt, acquittal must be granted. First, with respect to count 1, the strangulation count, Mr. Jackson asserts that no reasonable juror could find that all essential elements of that count have been met beyond a reasonable doubt. In making that motion, Mr. Jackson challenges all elements that have not been stipulated to, but I wanted to focus on 2 elements of the strangulation charge in particular. First, no reasonable juror could find beyond a reasonable doubt that Mark Jackson met the specific element or caused or create a substantial risk of physical harm. There was no evidence presented here today that demonstrates actual harm, no hospitalization, medical follow-ups. Police consistently testified that they saw no injuries. Ms. Comfort herself testified she was not harmed as well. As for creating a substantial risk of harm, no reasonable juror could find that beyond a reasonable doubt as well. The revised code, section 290101, defines a substantial risk as meaning a strong possibility as contrasted with a remote or even a significant possibility that a certain result may occur that certain circumstances may exist. Again, there's been no physical evidence showing that pressure had been applied. Beyond that, Ms. Comfort testified she'd been in an agitated mental state, given her PTSD, postpartum, and the other circumstances here. She testified she did not consider Mark Jackson a threat, and that even in spite of some triggering comments he made about her ex, she did not follow through to harm her at all during the interaction.
Didn't she say that that he was compressing her chest with his arms crossed, pushing down?
Yes, Your Honor, but with respect to the pressing down, I think she was consistently as to on top of her chest and consistently as well indicating she sustained no injury from that.
Right, but with his full weight, didn't she say with his full weight also?
Yes, Your Honor, however, that kind of goes into the second element as well. Again, and I would just reiterate, there's been no documentation of physical injury. With respect to element number 2, there's that by means of strangulation or suffocation. In the definition from the statute is strangulation or suffocation is defined as any act that impedes the normal breathing or circulation of the blood by applying pressure to the throat or neck or by covering the nose or mouth. I don't believe that nose or mouth is in contention here. So the real question is the application of pressure to the throat or neck and whether a reasonable juror could find that beyond a reasonable doubt. And Your Honor, Mr. Jackson's position is that the evidence does not support that element beyond a reasonable doubt. Ms. Comfort testified pressure had been applied to her chest directly, not to her throat. She testified she did a visual demonstration to officers where she crossed her arms up on her chest on the stand, not with respect to her throat. Officer Federico's testimony, when he was questioned what part of his body this happened to, he immediately answered chest, upper chest area, not making reference to the throat or neck. Officer Grove again testified to upper chest. Well, there was some conflicting testimony from Officer Witt and Officer Bowski, who admittedly did reference the neck being, or Mr. Jackson being in contact with the neck. Officer Witt additionally references that this was like a long, busy day. He can't recall where he was prior, which undercuts to some extent his recollection or the credibility of his testimony. With respect to Officer Bowski, he references to the throat bite, but conversely also mentions how even based on his first responder training, he observed no redness or bloodshot eyes, which he indicated were the only indicators, physical indicators of strangulation he would be looking for. Additionally, in questioning Ms. Confer on cross-examination, the state made repeated reference to her use of the word choked. But Ms. Confer's account of the events that occurred doesn't meet the specific legal definition of strangulation. One thing I would note is the Ohio Supreme Court bench card for non-fatal strangulation or suffocation gives some context. It notes that oftentimes court participants might use the word choked rather than the correct and legal medical term for strangulation. And it further states that the focus should be, quote, the facts described rather than the terminology used. And in this incident, it's based on Ms. Confer's testimony as well as testimony by a number of the officers. The facts described don't describe strangulation under the statute. Accordingly, in the light most favorable of the state, based on the evidence presented today, what's alleged here didn't constitute strangulation beyond a reasonable doubt given the definition of the statute. And Mr. Jackson was moved for judgment of acquittal in that charge. With respect to the domestic violence charge, I won't belabor the point. I simply just reiterate a lot of those arguments made as to the physical harm component of the strangulation statute. Again, there's a slight difference in the domestic violence cause or attempt to cause physical harm as opposed to the substantial risk of physical harm referenced in the strangulation statute. But again, Mr. Jackson reiterated the same arguments as to physical evidence showing injury or that pressure was applied, and again, particularly Ms. Confer's testimony as well. And again, would request that the court grant dismissal on the either. Thank you.
All right, Ms. Linden?
Thank you, Your Honor. Your Honor, in terms of the information that has been presented, looking first at the strangulation charge, this is the causing or creating a substantial risk, and risk doesn't mean that there has to be harm. And we've seen from each of the officers a demonstration about how this happened, and even when Faith Comfort herself demonstrated it, and she's put her fists kind of even up by her chin, shows that it went across her neck and her chest. She couldn't breathe. She does explain in her statement how she saw blurs. She was unable to breathe during that period of time. And so looking at that and looking at the fact that when someone can't breathe, that is a substantial risk to them. The state would submit that based on the testimony that you've heard, that in fact there was that risk, and in the light most favorable to the state that the Rule 29 should be denied. Her word was choked. And so when we look at that and we have the demonstration of choked, yes, I would agree it's not your normal definition of strangulation, but strangulation talks about the fact that it impedes the normal breathing. And here clearly, if she can't breathe, that impedes the normal breathing. And looking at the domestic violence charges, cause or attempt to cause physical harm, and not only did you see the demonstrations and hear what she said, but she also specifically says that the defendant said that he was going to abuse her like her ex, and abuse doesn't generally mean anything other than some sort of harm. So I would ask that you deny the Rule 29 motion.
All right, based on the applicable standard and the testimony, I'll overrule the defense motion. Does the defense intend to present any testimony?
We do not, Your Honor.
All right, is the defense resting?
The defense rests.
All right, Mr. Jackson, you understand you have a right to testify in this trial if you want to? You got to verbally answer.
Yes.
You also understand you have the constitutional right to not testify if you do not want to.
Yes.
If you decline to testify, nobody could comment on that decision. Do you understand that?
Yes.
And while it may be your counsel's advice not to testify, is it your decision to not testify in this case?
Yes.
Okay. All right, did Nicole give you the revised version?
Yes, Your Honor.
You want to look at that, and we'll come back and discuss it if there's anything to discuss?
Your Honor, I think Ms. Smith and I actually discussed it a little bit earlier, and the only thing that I can see is putting Faith Confer's name in the charge. And when it says stipulation, I understand after reading it again why it's listed, say, under the first count stipulation number 5, because it's 5 on our stipulations. But I think the way that we discussed it, that it might be just easier to say stipulation to that stipulation.
All right, I think what I changed this morning was, yeah, we can take out the stipulation number 1, stipulation 5, all that. But I think the language now is the parties stipulate and agree that the defendant, whatever the stipulation is, so that's how. So
And-
I'll eliminate stipulation with the number.
And I think that with family or household member, we talked about that, was there some, where that stipulation needed to be?
That family and household member is an element of each offense charged and appears to be listed under just one.
Just under what, domestic?
Yes, Your Honor. That's it, Your Honor. Other than that, I don't think that there wasn't anything else that we saw.
All right, so I'll make those changes, get that back to you. And then, once everything is done, then we'll start with the closing.
And I would say that looking at the verdict forms, I didn't see any changes there.
I did not have either, Your Honor.
Okay, did, the verdict forms that you have, does that list the offensive violence with the Cuyahoga case number?
I believe it does.
Okay, I don't know why that needs to be in there. I mean, the only issue is whether he's been convicted of
Felony
an
offensive.
felony offensive violence. So this morning I instructed her to take that out of
Okay.
the additional finding, because I don't think it needs to be in there.
I mean, for our purposes, I
I mean,
understand why, but
you've-
for
you've
theirs,
s-
I don't see it.
Right, okay, so I'm gonna take that out, but we'll get you that, and then, and we'll get started when you guys are ready, okay?
All right.
I was just looking at that again, Your Honor, it doesn't say family or household member, it just says dating, relationship, and strangulation, so we would not need that in count one.
Okay,
And
but,
it also is listed on page 6, following the first additional finding.
but it is, and that, I guess that's the point, it's in the additional finding, the definition, so,
That's fine.
okay. So, as it stands now, we're gonna eliminate those, the wording stipulation followed by the number. And then everything else is sufficient?
Yes,
according-
Your Honor.
Okay.
Thank you.
All right, so I'm gonna have Nicole print those out, give them to you guys. And then when do you wanna, how long do you need before we bring them in and start again?
I just need to make sure that I get my PowerPoint up on the screen,
Okay.
and then I'm good to go, Your Honor.
All right. Okay, so we'll get started as soon as you guys are ready. Okay?
Thank you, Your Honor.
that you're gonna get in this trial. The next phase of the trial is the instructions and the closing arguments of counsel. I will give you the bulk of the jury instructions, and then counsel will present their arguments, and I will give you the remaining jury instructions. You had a copy on your seat of the instructions. That's for your convenience. You can either follow along or not follow along, whatever you want to do. But that's completely up to you. I just found it's become easier for people to read as they're being spoken to. All right, you have heard the evidence. The court and the jury have separate functions. You decide the disputed facts, and the court provides the instructions of law. It is your sworn duty to accept these instructions and to apply the law as it is given to you. You are not permitted to change the law, nor to apply your own conception of what you think the law should be. A criminal case begins with the filing of an indictment. The indictment informs the defendant that he has been charged with the offenses. The fact that it was filed may not be considered for any other purpose. The plea of not guilty is a denial of the charges and puts in issue all the essential elements of each offense. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. For each offense charged in the indictment, the defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of that offense. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. If after a full and impartial consideration of all the evidence, you are firmly convinced of the truth of the charge, the state has proved its case beyond a reasonable doubt, and you must find the defendant guilty of that charge. If you are not firmly convinced of the truth of the charge, you must find the defendant not guilty of that charge. Evidence is all the testimony received from the witnesses, the exhibits admitted during the trial, and any facts which the court requires you to accept as true. Evidence may be direct or circumstantial or both. It is the quality of the evidence that must be weighed. Quality may or may not be identical with quantity. Direct evidence is the testimony given by a witness who has seen or heard the facts to which he or she testifies. It includes exhibits admitted into evidence during the trial and stipulations you were instructed to accept as fact. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. If you awake in the morning and you see the ground is covered with snow, that is circumstantial evidence that it snowed earlier. If you see human footprints in the sand, that is circumstantial evidence that someone had walked there. To infer or to make an inference is to reach a reasonable conclusion of fact which you may but are not required to make from other facts which you find have been established by direct evidence. Whether an inference is made rests entirely with you. Direct evidence and circumstantial evidence are of equal weight and probative value. The evidence does not include the indictment or the opening statements or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. Statements or answers that were stricken by the court or which you were instructed to disregard are not evidence, and must be treated as though you never heard them. You must not speculate as to why the court sustained the objection to any question or what the answer to such question might have been. You must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. Some exhibits may appear to have been deleted, redacted, or omitted. There is nothing improper about any deletions, redactions, or omitted material, and no one has tampered improperly with such evidence without the knowledge of the state, the defense, and the court. In fact, such deletions, redactions, or omissions have been done at the request and agreement of both parties. Any material that has been deleted, redacted, or omitted is irrelevant to your determination of the issues in this case. You are to infer nothing by what you think may have been deleted, redacted, or omitted. Do not conjecture or speculate on what was not presented to you in the exhibits. You are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You may use the tests of truthfulness which you use in your daily lives. These tests may include, but are not limited to, the appearance of each witness upon the stand, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which the witness testified, the accuracy of the witness's memory, frankness or lack of it, interest and bias, if any, together with all the facts and circumstances surrounding the testimony. By using these tests, you may assign to each witness's testimony such weight as you deem proper. You are not required to believe the testimony of any witness simply because he or she was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to decide what testimony to believe and what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. Evidence was received about the commission of a crime other than the offenses which the defendant is charged with in this trial. That evidence was received only for limited purposes of proving one of the elements of the offenses charged in this trial. The evidence about the commission of a crime other than the offenses with which the defendant is charged in this trial cannot be considered for any other purpose than the purpose identified. It was not received, and you may not consider it to prove the character of the defendant in order to show that he acted in conformity with that character. It does not follow that the defendant's past acts that he committed, the particular crimes charged in this case. The state has the burden of proving each element of the particular crimes currently at trial beyond a reasonable doubt. The state cannot satisfy its burden merely by implying the defendant committed these crimes because his other acts suggest a propensity to commit crimes. It is not necessary that the defendant takes the witness stand in his own defense. He has a constitutional right not to testify. The fact that he did not testify must not be considered for any purpose. Police officers have testified in this case. You are not to give any greater or lesser weight to their testimony based solely on the fact that they are police officers. In count one, the defendant is charged with strangulation. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the first day of January 2025 and in Lake County, Ohio, the defendant knowingly caused or created a substantial risk of physical harm to Faith Confer by means of strangulation or suffocation. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances in evidence. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon knowledge. When an act is a crime, a good motive or purpose is not a defense. Cause is an act or failure to act that in a natural and continuous sequence directly produces the physical harm to person, and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act. The defendant is also responsible for the natural and foreseeable consequences that follow in the ordinary course of events from the act. Strangulation or suffocation means any act that impedes the normal breathing or circulation of the blood by applying pressure to the throat or neck or by covering the nose and mouth. Substantial risk means a strong possibility is contrasted with a remote or even significant possibility that a certain result may occur or that certain circumstances may exist. Physical harm to persons means any injury, illness, or other physiological impairment regardless of its gravity or duration. The parties stipulate and agree that the date of the alleged conduct was January 1, 2025, and that the alleged conduct occurred in Lake County, Ohio. There is a first additional finding to count one. If your verdict is guilty, you will separately decide whether the state proved beyond a reasonable doubt that Faith Confer was a family or household member of the defendant. If you find the defendant not guilty of strangulation, You will not consider whether the alleged victim was a family or household member of the defendant. Family or household member includes, 1, a spouse living as a spouse or a former spouse of the defendant who is residing or has resided with the defendant, and 2, the natural parent of any child of whom the defendant is the other natural parent or is a putative or other natural parent. Persons living as a spouse means a person who is cohabiting with the defendant or who is cohabited with the defendant within 5 years prior to the date of the alleged commission of the act in question. Reside means to live in a place on an ongoing basis. Residing is something more permanent in nature than just periodic visits, even if those visits are overnight or last several days. Cohabit means living together at the residence, or if not living at the same residence, sharing of family or financial responsibilities and consortium. The parties stipulate and agree that the defendant and Faith Confer were family or household members at the time of the offense as defined in the Ohio Revised Code, section 2919.25. Second additional finding to count 1. If your verdict is guilty, you will separately decide whether the state proved beyond a reasonable doubt that Faith Confer was a person with whom the defendant was or had been in a dating relationship. If you find the defendant not guilty of strangulation, you will not consider whether the alleged victim was a person with whom the defendant was or had been in a dating relationship. Person with whom the defendant was or had been in a dating relationship means a person who at the time of the conduct in question was or had been in a dating relationship with the defendant, or within 12 months preceding the conduct in question had a dating relationship with the defendant. Dating relationship means a relationship between individuals who have or who had a relationship of a romantic or intimate nature. Dating relationship does not include casual acquaintanceship or ordinary fraternization in a business or social context. The parties stipulate and agree that the defendant and Faith Confer were in a dating relationship at the time of the offense as defined in the Ohio Revised Code, section 3113.31. Third additional finding to count 3. If your verdict...
I'm sorry, Your Honor, I believe this was to say to count 1. That just wasn't changed.
I'm sorry.
I apologize.
Thank you.
I know we talked about it, but it,
All right. That heading should read third additional finding to count 1. If your verdict is guilty, you will separately decide whether the state proved beyond a reasonable doubt that the defendant was previously convicted of a felony offense of violence. If you find the defendant not guilty of strangulation, you will not consider this additional issue. The parties stipulate and agree that the defendant, Mark Jackson Jr., was previously convicted of or pleaded guilty to a felony offense of violence. In count 2, the defendant is charged with domestic violence. Before you find the defendant guilty, you must find beyond a reasonable doubt that on or about the first day of January 2025 and in Lake County, Ohio, the defendant knowingly caused or attempted to cause physical harm to a family or household member. Knowingly caused physical harm, family or household member, and a person living as a spouse have the same meanings as above. A criminal attempt occurs when one knowingly does anything that is an act constituting a substantial step in a course of conduct planned to culminate in his commission of the offense. To constitute a substantial step, the conduct must be strongly corroborative of the actor's criminal knowledge. The parties stipulate and agree that the date of the alleged conduct was January 1, 2025, and that the alleged conduct occurred in Lake County, Ohio. The parties stipulate and agree that the defendant and Faith Confer were family or household members at the time of the offense as defined in Ohio Revised Code, section 2919.25. There's an additional finding to count 2. If your verdict is guilty, you will separately decide whether the state has proved beyond a reasonable doubt that the defendant was previously convicted of domestic violence. If you find the defendant not guilty of domestic violence, you will not consider this additional issue. The parties stipulate and agree that the defendant, Mark Jackson Jr., was previously convicted of or pleaded guilty to domestic violence. If you find that the state proved beyond a reasonable doubt that all the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be guilty as to such offense or offenses according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be not guilty as to such offense or offenses according to your findings. The charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your finding as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of any one or all the offenses charged. The parties stipulate that the alleged offenses took place on January 1, 2025. You will have with you in the jury room the following verdict forms. And there are one verdict form for each count. Each states, "We, the jury, being duly impaneled and sworn, find the defendant," and there is a blank. You will fill in either guilty or not guilty according to your findings, and then as I discussed, there are additional findings on these two counts if applicable. There is a place for 12 signatures. Your verdict must be unanimous, and all of you must sign on the verdict form in ink on the line next to your number. All right, counsel will now present the closing arguments. Remember, the closing arguments of counsel are designed to assist you. They are not evidence. Ms. Linden?
Thank you, Your Honor.
In addition, before Ms. Linden starts, the state will go first, followed by the defense, and the state will have one last opportunity to address you since they have the burden of proof. Go ahead, Ms. Linden.
Thank you, Your Honor. Well, ladies and gentlemen, it's a little cooler today than it was yesterday, so hopefully everyone will be awake. In this particular case, one of the things that we have to prove to you, and you see from the charges, is that this occurred in Lake County, Ohio, and this is within the jurisdiction of this particular court. And there's a stipulation, and when you hear stipulation, I know that it's been repeated a lot, but basically that means it's something additional that we've agreed is already true. Normally we would put in a lot of evidence about certain facts, but if we agree that something's true, it's not disputed, you don't need to worry about that. When you look at the fact that the date is January 1st of 2025, that's not in dispute either, that's stipulated. And that this happened at Hollydale Apartments in Building 4, 107. So you had the opportunity, and you'll get a chance to look at these particular photos. This is the Hollydale Apartments where the officers responded on the date in question. And this is New Year's Day. They were busy that day, but they did in fact respond to that apartment complex. And when they responded, they went to apartment 107. This is how the door looked on that particular day. And one of the things that you heard discussed when they respond is to this 911 text. And that's a little unusual for them to get a 911 text. But when they get this 911 text, the dispatcher actually calls and says, "Is everything okay?" And you hear that Faith responded no, and then hung up. And so then the officers respond. And when they respond there, one of the things that has been discussed is this little area here, there's a peephole there. And you heard Faith talk about the fact that the defendant was behind the door, but that prior to that, the reason that the door didn't open right away is he's the one who looked through the peephole. So consider the fact that he's looking through the peephole, then and you can see the way where the handle is for the door, how the door swings in. He's behind the door. There may not have been a lot of room there, but he was there behind the door after looking through that peephole. You have to look at that and say, well, why is he doing that? So when the police respond, they come down the stairs and they come to the apartment there, and they initially knock on the door and no one responds. And when someone finally does respond and she comes out, they realize that they need to say something like, okay, why don't you step out into the hall? They could tell something was wrong. And one of the things that you heard them talk about is the fact that you have Faith Confer who's looking at the police officers, and she's doing this where she's nodding and using her eyes to signal that somebody's behind the door. And what I would ask you to consider is, first of all, when you talk about somebody texting 911, that's because you don't have to be on the phone and you don't have to talk. Nobody hears what you're saying. If you then move afraid of what the person who's in the apartment is going to do, those are things that you would do. She doesn't even want to talk necessarily right outside the apartment, even when the door is closed, and she's whispering. And one of the things that she talked to you about was the fact that she didn't necessarily want him to hear what was being said. Now she says a little bit more like, well, I just didn't want him to know that I wanted him out of the apartment. And if you look at what's reasonable in this case, she knew that she texted 911. She knew that the police had responded because of what she did, and she certainly didn't want the defendant to know that. In fact, what we talked about and what she said was, I told him that I didn't call 911, and technically that was the truth. She didn't call, but she texted. And she told the defendant, when the dispatch called back, and they said, do you need anybody to come out and help you? And she said no. What really happened was, are you okay? And she said no. So think about also in that respect, why would she do that? Why would she not specifically tell the defendant what she actually did? So she is taken by the officers and she goes upstairs from this particular area here where the apartment is, where the door mat is. They come up the stairs, so she comes up the stairs here, and then there's another set of stairs that goes up. And one of the things that they talk to you about is this is where they're talking to him, to Faith, and this is where she's writing her statement. Still not really far from the apartment, but at least far enough away with a closed door that maybe she can talk to the officers and let them know what happened. When they see her, she's crying. She has red eyes. This is how they observe her on this day. And these photos are taken after an hour. These are the photos that Officer Federico took afterwards. So you can still see, even after that whole period of time, how upset she is. And one of the things that has been discussed a lot is the fact that there aren't any visible injuries. And I know that we talked even in jury selection about the term strangulation and the way that the revised code is. And I didn't write it, so I know that when you initially think of that and you hear the word strangulation, there's that what comes to your mind. And we talked a little bit about that in voir dire too, but you have to look at the way that it's defined. And the revised code is defined in a certain way, and you have to look at what the definition means and kind of set aside what you think initially that would be. Like I said, when you think of choking, everybody thinks of like hands around the neck. That doesn't necessarily mean that. I'm sure you've encountered individuals before that have been choking, and it wasn't as a result of that. It wasn't as a result of somebody's hands around their neck. So strangulation here, again, we stipulated to the date, we stipulated to where this happened. This involves Faith Comfort, and that the defendant here knowingly caused or created a substantial risk of physical harm to her. They were in a dating relationship. We've already discussed that, and that's been stipulated to. There's a prior conviction or a plea to a felony offense of violence that's stipulated as well, and it's by means of strangulation or suffocation. So let's talk about strangulation or suffocation. This means any act that impedes the normal breathing. So when you talk about the way that you're normal breathing, if somebody says, I couldn't breathe, if she's talking about pressure on her chest, and each of the officers demonstrated to you how this happened, that he crossed his arms, put it over her neck and chest, and pushed down with all his weight to the point where she could not breathe. She started to see blurs as a result of it. So if you're talking about an act that impedes the normal breathing, what he did impeded her breathing. She couldn't breathe. She specifically said that. And here it's applying pressure to the throat or the neck, or by covering their nose or mouth. And no, it's not a matter of covering the nose or mouth, but there is significant pressure that's put on the neck and chest here for Faith Comfort, and she is unable to breathe as a result of it. So I would also ask you to think about the way that that's done. If somebody uses their hands, you would expect to see some kind of visible injury, but if you're talking about somebody on top of somebody pushing down, there may or may not be any kind of a visible injury as a result of that, but I would ask you to take into consideration the fact that she does talk about the fact that her voice is hoarse and she's talking the way that she is as a result of what the defendant did and the fact that the defendant was choking her. That's her words. So, one of the things that you also got to hear was her voice and what she was saying on the date that it happened, when this was fresh in her mind and after this had just occurred. So she talks about the fact that he says he's going to treat her like her ex, he's going to abuse her like her ex so that she can say that he abused her. So why do you say something like that? So she said that her voice doesn't usually sound like that. She explained what happened to Officer Witt. She kind of went through, although a shortened version, she told him. So she's telling several officers what's going on. She said it happened for about 15 minutes. He was choking me and I couldn't breathe. I told him to leave her alone. He wouldn't. He held her down. I'm going to abuse you like your ex so that you can say that I abused you. So there's a dash cam.
Starting to hurt you all the time? What did you say? He was mentioning one of my exes, and my ex's name always gets filled with my raping for me. He took 3 ounces of rape on me.
Okay, not the best audio, right? I mean, you can hear the clicking, it's hard to hear, but you'll have this with you to be able to listen to it. But you can hear her voice. Even over a dash cam, you can hear her voice. You heard her in court, not the same voice. She's clearly talking about what happened to her, to the officer. And the interesting thing that I would point out is that she didn't realize that all this was recorded. So when she came into court here and she wanted to talk to you now in July about what happened, she didn't realize that she was recorded. And that's what she actually told the police when it actually happened, and her fear and her voice, that was actually captured on an audio.
Starting to hurt you all the time? What did you say? He was mentioning one of my exes, and my ex's name always gets filled with my raping for me. He took 3 ounces of rape on me. Is your voice going around like that? No. Why? When did it feel like that? After you told me.
Her words, when did it start to be, her voice start to be like that after he choked her?
Is your voice going around like that? No. Why? When did it feel like that? After you told me. What's it all over? Text messages on his Facebook.
So, not just one, not two, but 3 separate officers she's talking to us about and saying what happened, saying the same thing each time.
He just started talking to me, I'm like, I can't breathe.
That's her words. She was choking and she couldn't breathe as a result of what the defendant did.
And when he came in there, I was like, please leave me alone. I texted him. I was like, please leave me alone. I don't want to talk anymore. He was like, no, I'm not going to leave you alone. I'm going to treat you like your ex did. So you can say that I abused you.
She's still annoying clicking, but you can hear a little bit better each time what she's saying.
he held you down? He told me he was gonna make me feel like my ex did.
Is there a particular reason why he said that?
I told him that he was holding me down. He was acting like my ex, because that's what my ex did when he raped me, and it was triggering my PTSD.
But why did he hold you down?
Because he was mad.
Mad.
Because I wanted to see his phone. I was showing him something that I found. And then I was looking on that message on his phone.
Okay.
All this because he was mad about the phone and a Facebook message. Not only did she tell each and every officer what had happened, but in the end, before they left, she actually brought them into the brought Officer Federico into the apartment to show where this happened. And when you look at the bed, you can see that it's not a large bed. And you have a screaming, crying child, infant child, who's on the bed as well. Faith just went in there to get away, to walk away, to not deal with this. She wanted some space. And when she sits down on the bed, what does he do? He pushes her down on the bed with all his weight, with the baby there. And she can't even roll to get out of the way so that she can breathe, because she doesn't want to injure the child. Now, if you think about the fact that she is concerned about injuring her child just because she's going to roll one way or the other, you have to think about what kind of position she's in at that point in time and why she would be afraid of that. She drew something for me to show me a little bit about this, and you can see that what she drew is the way that the room looks. Now, maybe a crude drawing, but you can tell that there is a bed there. The bed is facing one way, she was facing another way. She explained that she was laying down on the bed there because he pushed her down there, and that's why she's there. He's on top of her with all his body weight, and the child is on the bed, and then she talks to you about the fact that he's on top of her and she can't breathe. So when you look at the bed and you look at not a whole lot of places to go, I mean, she talked about that there's a lot of stuff on this side and she hadn't gone there. She does have pillows on her bed, but there's really nowhere for her to go. You have a child on one side and pillows on the other, and she's there and she's trapped with the defendant on top of her. So it's caused or created a substantial risk. So this is where there's a possibility, and you'll see that in the definitions is as contrasted with a remote or even a significant possibility. So if you say that a certain result may occur or that certain circumstances may exist, when you are pushing on someone's neck and they can't breathe and they get to the point where they're seeing blurs, I want you to think to yourself, is that something that caused or created a substantial risk to her? And she said this is going on for a while, and she finally realized, I'm not going to get out of this unless I just do everything I can to stop struggling and calm down. Maybe he'll let me out. But at that point in time, again, she can't breathe. Physical harm means any injury, illness, or other physiological impairment regardless of gravity or duration. So you're talking about the normal and healthy way that your body operates. And if you're talking about physiological impairment, it can be something as simple as you're stressed out, your heart's racing, you're sweating. So I know Ms. Smith went through a number of different parts, different aspects of some things that can happen during strangulation, but that doesn't mean that that's always the case. And here, it's when you're talking about any injury, illness, and it says regardless of the gravity or duration. So it doesn't matter how serious it is or how long it lasts. So if you have a hoarse voice and you can't breathe, even for a period of time, that's enough. So what did she say? He was yelling. He wouldn't leave her alone. He followed her into the bedroom. He pushed her onto the bed. Not something where she just laid back. He pushed her. His whole weight was on her. His arms were crossed underneath her chest and neck, and she couldn't breathe. She said it felt like 15 to 20 minutes. She couldn't roll to the side. He was going to treat her like her ex. And again, this whole argument is over a phone and Facebook. Here, again, we don't have to prove what the motive was, but you heard the testimony and you know why this is happening the way it is. Now, should Faith have said anything comparing the defendant to her ex? Probably not. But when he knows full well what her ex did to her and he's doing something similar, saying, I'm gonna treat you that way, you have to think of even what kind of physiological response she would have to that. So this is what the police knew. She texted 911. She said she wasn't okay. When she gets to the door, she's alerting them with her eyes that he's behind the door. She's very upset. She has red eyes. She's crying, and it's continued on and off for about an hour. She had a raspy voice, and she was whispering. Okay, we look at domestic violence here. Again, the date stipulated that it happened in Lake County, and here that they're family or household members, that's already stipulated too, and that the defendant has a prior conviction or pled guilty to domestic violence, that's stipulated too. So what we have to look at is, did he knowingly cause or attempt to cause physical harm to her? Okay, so it doesn't matter what your purpose is, but if your conduct will probably cause a certain result, or you know that it will be of a certain nature, or you have know that those circumstances probably exist. If you think about him even using his full body weight, pushing her on the bed. If you think about the fact that while he's on top of her, that he has his arm crossed and he's pushing down on her chest. Okay. Now I realize that she said that she has kind of a fat neck. Those her words, not mine. And so there's that issue, but she is who she is, and she was who she was, and the fact that what he did made it to the point where she couldn't breathe. When you do that, you put your full body weight on somebody, you press down on their neck and their throat area, I'm not sure what you expect. If you're going to abuse somebody or treat them like their ex, and her ex choked her before, and he's saying that and doing something similar, you have to look at that. So an act or failure to act which in a natural and continuous sequence directly produces a physical harm. So here, none of this would have happened if he hadn't done what he did physically to her. And so it can simply be an attempt. So what he's responsible for is the natural and foreseeable consequences. So here, luckily, she didn't pass out. But she did see blurs, so she got to the point where her breathing was seriously impaired. He just kept, even it didn't matter to him. He didn't care that she couldn't breathe. He said, no, I'm not going to stop. And he continued to do this. Okay, again, we talked about these are the things that Faith said. What word did she repeatedly use? Now, I understand that choking doesn't always mean choking the way that we think, but that was the choice that she used. The word that she used, that's what she said happened with her ex, that she had been choked. Now, the way that she had been choked could certainly be different, but that was her word, not my word, not the police's word. They didn't tell her, say, hey, were you choked? That's what she told them. So she was afraid of the defendant. How do we know that? She went into the bathroom to use the phone. She didn't sit in the same place. She actually went to a different room. She did not call 911. She texted. When dispatch calls back, she says, no, she's not okay. The police are there within 5 minutes, and she first doesn't open the door right away. She says that the defendant looked through the peephole, and then she does signal again with her eyes. So she's just going through things in whispers so that the defendant can't hear. So again, they go in and they're able to take photographs, and if you look at the fact that, yes, the door is there, if she's standing in the door frame here, he's directly behind the door, right over here, just close. And one of the things that I would point out, I know that they say it's a narrow area, but he's right there next to her. That's not a big area. He's right behind that door. So if she says anything wrong, he's right there within an arm's length. These are the stipulations that we've already talked about. So we ask at the close of the evidence, and in the case here, when you go back and you deliberate, that you find the defendant guilty as charged. Thank you for your time and attention. I
Thank you, Ms. Smith.
Members of the jury, State of Ohio, may it please the court. Hello again, Team Innocence. Now is the point where you decide whether the State of Ohio has produced evidence of the quality and weight to convince you to change New Jersey. You heard the judges reviewed some of the jury instructions with you, and I want to touch on some of the points that are included there. The jury instructions refer to credibility of the witnesses and the evidence, and how you have the freedom and in fact are invited to apply tests to determine what to believe and what not to believe. The jury instructions make it clear that you may believe all, part, or none of a witness's testimony. Now the interesting thing here is one thing you can't do is believe everything that Faith Comfort has testified to. You would reach a contradictory conclusion. You are able, as part of your credibility test, to make your own observations of Ms. Comfort throughout her testimony. You saw that as the state pressed her and she indicated that she felt trapped, she felt restricted, she didn't like answering questions. As she did that, you watched her tear up. And as Ms. Comfort teared up on the stand, what happened to her voice? Her voice started to change. What happened to her eyes? Her eyes became puffy. Ms. Comfort appeared on the stand in trial yesterday. The way that officers described her on the night of this incident. When considering the credibility of a witness, you can also consider the interests of that witness. Ms. Comfort made multiple statements to multiple parties, and she testified that she had multiple purposes for those statements. Ms. Comfort testified that on January 1st, her purpose was to get Mark out of the house. She was pissed. She'd been going through his phone on New Year's Eve. She's home. She doesn't want to be touched. She's experiencing postpartum depression. She feels that her relationship is threatened by that text message. So her purpose, so she became angry and she wanted Mark out of the house. And as she testified, her purpose in making the statements that she did and request that night was to get Mark out of the house. The next day she indicated her version of events were somewhat different. Well, the night had passed. She wanted Mark out of the house for the night. She wanted time to calm down. She wanted space to herself. So the next morning, what she wants is Mark home. She's calmed down. They are a family unit. Even the personal, intimate relationship between Ms. Comfort and Mr. Jackson being threatened would not threaten the stability of their family unit, she testified to. Ms. Comfort may have had another purpose in providing the information that she did and potentially withholding other information from law enforcement when she gave her statement to them on January 1st. As Ms. Comfort went line by line through her written statement, she filled in a lot of details. There were things she left out that night. She hit Mark first. She took his phone. When she didn't want to argue with him, she was in fact arguing with him. When he was yelling, he was actually yelling back at her. They were in a verbal disagreement, as happens between partners. The blanks that Ms. Comfort filled in for us on the stand could potentially constitute admissions of criminal conduct to law enforcement had she shared it with them that night. She wanted Mark out of the house. She didn't want to go to jail. Now, interestingly, it could be easy to forget, this trial is about Mark Jackson. your decision, you're gonna be deciding making one of the most important decision in Mark Jackson's life. Now, we all understand based on the testimony that we heard that what affects Mark Jackson also affects Ms. Confer. But the only one who had anything to say about Mr. Jackson's alleged conduct was Faith Confer. The officers who had the opportunity to observe Mr. Jackson that night noted that as they approached the house, they heard talking. Now, the dog barks when it hears a noise. The baby cries, as Faith testified, the baby cries when Ms. Confer and Mr. Jackson argue. As officers approached, they heard talking. As when Faith opened the door, Jackson was holding the baby. It'll be up to you to decide whether him standing behind the door was a threatening and menacing action on his part. Now, Mr. Jackson did not testify today. We discussed this at injury selection, and every one of you indicated that that would not cause a problem for you. I'm going to ask you to stay true to your word. But just because Mr. Jackson didn't testify, it doesn't mean that you didn't learn anything about him. Mr. Jackson has been present in the courtroom with you throughout this entire trial. Mr. Jackson heard that the mother of his child had said some things about him that might make somebody angry. And some of those things he heard for the first time during this trial. You guys can decide and discuss among yourselves whether you made any observations about Mr. Jackson that suggests that he was enraged, that he was out of control, that he's unable to receive bad news and act appropriately. Additionally, Mr. Jackson, as described by officers, was calm and cooperative on scene. He did not lash out at Ms. Confer when he was being led away in handcuffs on New Year's Day. He did not resist officers when they led him away that night. And before the officers could place Mr. Jackson in handcuffs, he handed his infant son, who was not crying, to Faith. Faith testified that her client's a stay-at-home dad. Now, I'm going to ask you, when you make decisions about Mr. Jackson today, first, to take very seriously the court's instruction that his prior conviction is only to be considered for the element that he previously has been convicted. The stipulation was read to you at the beginning of this trial, and it indicates the prior conviction was in the year of 2021. Ms. Confer testified that she and Mr. Jackson began dating in June of 2023. Mr. Jackson is sitting here in 2025. Would you grow? One of the purposes of our system is rehabilitation. So we would ask that you rely only on the testimony that you heard today and yesterday and your observations of Mr. Jackson as you deliberate this matter. I want to take a look at the big picture here. If you'll indulge me in a forest and trees analogy here, Mr. Jackson is going to ask you as you deliberate to look at the forest. Consider all of the evidence you heard. Consider what was present. Consider what was missing. The state has effectively asked you to look at one tree. They want you to look at Ms. Confer's written statement, the summary of the various things that she told officers all within 1 hour as the truth. That's not up to the state, because the truth is up to you to decide. So when you go back to deliberate, I'm going to ask you to take a look at all of the evidence, to decide, based on all of the evidence, whether or not that statement that Ms. Comfort made is the truth and the whole truth. The assistant prosecutor pointed out that we may have gotten a little ahead of ourselves with the way that strangulation was used in this trial. The word, well, and the assistant prosecutor indicated her belief that the general population believes that choked means somebody's hands are on your neck. I'm going to push back on that a little bit because either I'm not a member of the general population or I'm mistaken. But to me, choke means that there's a foreign object lodged in your airway and you can't breathe. Strangulation and choked are not synonymous. Additionally, Ms. Comfort testified that she has her own definition of choked. She felt like she was choking because she felt like she couldn't breathe. If Ms. Comfort had been strangled by the legal definition given to you by the judge, which includes, so I don't get it wrong, and is located in your jury instructions on page 5 if you're trying to follow along. Strangulation or suffocation means any act that impedes the normal breathing or circulation of the body by applying pressure to the throat or neck, or by covering the nose and mouth. Ms. Comfort testified that at no point did Mr. Jackson apply pressure to her throat or neck. It hasn't been argued or alleged that he covered her nose or mouth. Now, the state has placed great emphasis on any act, and because she couldn't breathe because of the pressure on her chest, but the law requires that the difficulty breathing be the product of applying pressure to the throat or neck, and that did not happen here. If that had happened here, what would you expect to see? Because if we're going to look at the whole forest, we have to look at the totality of the circumstances. Well, the officers described the apartment. I believe it was Officer Witt testified that he, upon arrival, expected to see an apartment in disarray. The apartment was not, in fact, in disarray. You will have photos of the bed to consider. When you think about the written statement, what's contained in that written statement, describes a 20-hour struggle where she could not breathe, could not move. Now look at the photo. I'm talking about a twin bed. Their infant son was on the end of the mattress. There are a number of pillows and other items towards the top of the bed. So they were effectively working with 1/3 of a queen-size bed in a 20-minute struggle. And that bed shows no sign of a struggle. All of the items on the floor, it appears, that were there at the beginning of this 20-minute incident are still on the bed. There was no testimony that Legend fell off of the bed while this happened. There are not always physical injuries during a domestic violence, where domestic violence has occurred. There are not always observable signs where strangulation has occurred. But in the absence of both physical signs and physiological symptoms, when the surrounding evidence doesn't suggest that there is more underneath the surface that officers cannot see, the fact that there can be invisible injuries does not mean that they exist. The absence of injuries, although it is not a decisive factor, is relevant. Officer Federico testified. That's why when he observed no injuries to Ms. Comfort's neck, in a location where you would expect to see injuries based on what she described, he photographed it anyway, because the absence of evidence is just important as the presence. Faith Confer's statements, multiple statements that she made, are most consistent in their inconsistency. But they aren't entirely contradictory either. So let's make it make sense. Faith Comfort testified why she said what she did to police on January 1st. She included in her testimony to you things that she didn't tell police. She feels that she started it. She struck him. She was still yelling and fighting with him throughout, and he told her that he would let her up once she calmed down, and in fact he did just that. The different statements given by Ms. Comfort are not confined to just what you heard today over the last 2 days directly from Ms. Comfort, or what you heard that she reported to police on January 1st. When the state of Ohio was questioning Ms. Comfort yesterday, they referred to a statement that Ms. Comfort made to JFS. For those of you that aren't familiar, it's the Department of Jobs and Family Services. She gave them a different version of events and acknowledged that on the stand. Well, she had a different purpose there. She wanted JFS out of her house and life. Faith Comfort testified to us what she told police, why she said it to them, and why she started making the choking allegation to start. Ms. Comfort testified that she told them she wanted him out of the house. An officer said, "We can't make him leave, he lives here." And she argued that, but it's only my name on the lease. Unfortunately, that's residency has more to do with just whose name's on the lease. And police explained that to her. But she wanted him out of the house. She was not gonna get that based on what she told them so far. And they're asking her about choking. Did he have his hands on your neck? Did he do this? Did he do that? Leading questions instead of asking her what happened. So she seized the opportunity and she got him out of the house. Ms. Comfort testified to you why she perceived things the way that she did on that day. Because nothing about this argument, this trial, is intended to make Ms. Comfort out to be a bad person. Clearly, she did not tell the entire truth every time she spoke. But as you heard through her testimony, Ms. Comfort's perception of events is altered by her past experiences. And Assistant Prosecutor, please object if I misstate this at all. But I don't think that there is any disagreement amongst anyone in this room that the domestic violence that Ms. Comfort testified to that she experienced with her ex was of horrific proportions. It still affects her today, and it makes sense that it does, but it doesn't mean that Mark Jackson assaulted her that day. It was a horrific experience, so she compared Ms. Mr. Jackson to tone the ex who did that to her. And he does take that personally. It does hurt. But that is why he restrained Ms. Comfer that day. He restrained her on the bed until she calmed down. What he did not do was strangle her. What he did not intend to do was cause her harm. It was 2 a.m. Where's he on New Year's Day? Where's he gonna go? He can't leave the house. His son is there. His partner is exhausted, as she testified. She didn't think it was gonna be that bad, but it was horrible. And he learned from his prior experiences. The version of events that I just laid out for you is only one of many conclusions that you can draw from the testimony that you heard in this case. I'm not asking you to agree with me on every single thing that happened. But members of the jury, just like the police, you now get to use all of your senses as you consider the evidence with one another. Your observations are relevant to your determination. It is your decision what was truthful and what was not. It is your decision whether or not Ms. Confer was a victim in this instance. It's your determination to make whether her scratchy throat and puffy red eyes were the result of her screaming and crying or the result of something more nefarious. We talked a little bit in this close about the absence of evidence, or where things that you would expect to see were missing. I want to take you through some of those that Ms. Confer testified to. According to Ms. Confer's testimony in court yesterday, Mr. Jackson did not, at any point, apply pressure by any means to her neck. He did not apply pressure by any means to her throat. Based upon her own experience of those events as they unfolded, she did not feel like her airway was restricted, although she felt like she couldn't breathe. There are other reasons to feel like you can't breathe. She did not feel that her blood flow was restricted. She agreed that his body weight on top of her was for the purpose of restraining her. She did not lose the ability to speak. She did not become unable to scream. She didn't lose consciousness. She didn't lose bladder control. She didn't lose bowel control. She didn't lose any memory. She did not have a single mark, scrape, or bruise on her neck. She didn't have a single mark, scrape, or bruise on her body. She wasn't in pain. She wasn't injured in any way, shape, or form. Not only did she not want EMS to come and assess her, law enforcement and first responders didn't believe it was warranted. Despite the fact that strangulation was alleged and the invisible injuries that can come along with strangulation, at no point after this did she seek medical treatment. Never felt like she needed to see a doctor. No bruises or marks developed in the days after. She had no broken capillaries in her eye or the skin on her face. Members of the jury, I submit to you that Faith Confer may have given you the whole picture for the first time since this occurred. Because the purpose of this trial is finding the truth. It was the first opportunity she had to deliver the truth in its completeness without any other agenda. And with that in mind, members, ladies and gentlemen of the jury, I ask you to return the only verdict that is possible in this case, and that would be a verdict of not guilty.
Thank you. Ms. Linden.
Thank you, Your Honor. Reason and common sense are two things that you're supposed to use when you make your determination. So I'm just gonna ask you a couple questions I want you to think about. When the defendant is present in the home, she texts 911, gets a call back, and only uses the word no and hangs up. she's afraid. Why? Because the defendant's there. When she talked to Job and Family Services, it wasn't about the child. Why did she say what she said when she answered this? Because he was there. When she testified yesterday, who was in the courtroom? Who was here? The defendant. So I would ask you to take that into consideration when you have a situation where officers respond to a 911, not just a regular call, a 911 text, and she has the protection of the police outside the earshot, hopefully, of the defendant, what she's able to say. She wasn't, I mean, he's in the courtroom yesterday too, so of course, think about the fact that there have been 6 or 7 months that have passed, and think about what she said when it actually happened, when the events were close in time to when it happened, and how upset she was, and the fact that she was afraid. Ms. Smith would have you believe that this is all about him getting out of the house, but how many times did you hear the officer say that she just said she wanted him out of the house? And how many times did you hear her say that on the audio? That's not why she called 911 or texted 911. She told you why that happened, because of what he did. Ms. Smith would have you believe that somehow she's withholding information. And that's, I believe she maybe misstated it, but it wasn't 20 hours, it was 20 minutes, that she may have misstated some things. And if you're, think about reason and common sense, if you're gonna write out a statement, sometimes maybe you don't put every single detail, but you put what's important, don't you? When I asked her about the whole, did she hit him at some point in time? Yeah, she did. 20 minutes prior, she smacked him. This is more than a verbal disagreement between the two of them. This verbal disagreement became physical. And when you have a situation that's just a family unit situation, a lot of times that's just in the home. But when it becomes a crime and when it becomes a physical attack on someone, ask yourself, is that when the police get involved? I mean, clearly, this is not a situation where she wanted to get on the phone call, say, hey, police, come here. Wasn't yelling and screaming, but again, take into consideration it's because he was there and she knew what he could do. Now, the other thing that was stated was she was the only person who talked about what happened. Well, she's the only person who knew what happened. She was the only person that was there. Domestic violence cases and domestic disputes, as we talked about in voir dire, that happens in private. A majority of the time, there aren't witnesses to that. But she told the police what happened over and over and over and over, and then she wrote it. And again, think about the fact that when they're talking about the defendant's not yelling, screaming, doing anything to her when the police arrived, well, the police arrived. Not 1, 2, 3, 4, 5 officers there. So take that into consideration while you're on your best behavior. And yes, the situation that Faith went through, horrible. Horrible what she went through with her ex. But she explained that to the defendant. And despite the fact that she explained how horrific that was, she said, you're treating me like my ex because her ex choked her before. Ms. Smith also talked about the forest and the trees and everything, but I would ask you, using even that analogy, a tree has a lot of branches, has a lot of leaves. Tree's still a tree, crime's still a crime. May not have a bunch of trees, but you got 2 here. And again, the state's not hiding anything. We I agree, you don't see any visible injuries, but that, the cause or attempt to cause, the fact that there are physiological symptoms, the fact that she couldn't breathe, that her breathing was impeded, the fact that she talked about how this happened, and that every single time, except for trying to backpedal a little bit yesterday while the defendant's sitting there, it's all about the pressure on her neck, her chest. So I would just ask you to think to yourself, you know, just because you can't see it doesn't mean it's not there. And one of the things that my co-counsel and I talked about before, and I think this is a good analogy, just because you can't see the air doesn't mean it's not there. Thank you.
Thank you. We will resume the instructions on page 9 if you want to follow along. The court cannot embody all the law in any single part of these instructions. In considering one portion, you must consider it in light of and in harmony with all the instructions. The court has instructed you on all the law necessary for your deliberations. Whether or not certain instructions are applicable may depend upon the conclusions you reach on the facts. If you have an impression that the court has indicated how any disputed fact should be decided, you must put aside such an impression, because that decision must be made by you based solely on the facts presented to you in this courtroom. You may not discuss or consider the subject of punishment. In the event you find the defendant guilty, the duty to determine the punishment is placed by law upon the court. Circumstances in the case may arouse sympathy. Sympathy is a common human emotion. The law does not expect you to be free of such normal reactions. However, the law and your oath as jurors require you to disregard sympathy and not to permit it to influence your verdict. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence and make your finding with intelligence and impartiality, and without bias, sympathy, or prejudice, so that the state and the defendant will feel that their case was fairly and impartially tried. If during the course of the trial the court said or did anything that you consider an indication of the court's view on the facts, you are instructed to disregard it. When you go to the courtroom, your first function will be to select one of your number to serve as a foreperson. The person you select to preside over your deliberations does not have any greater power, nor does that person's vote have any more importance than any other jurors. He or she serves the purpose of helping to conduct your deliberations in an orderly manner and to give each of you the opportunity to express your opinion. One additional duty of the foreperson is to see to it that the verdict forms and any exhibits are returned to the court after you reached a verdict. If you took notes during the trial, you may take your notes to the jury room. The fact that the notes taken by a juror support his or her recollection in no way makes his or her memory more reliable than that of the jurors who do not take notes. All notes will be returned to the bailiff for destruction when the jury is discharged. The court will place in your possession the exhibits, a copy of the instructions, and the verdict forms. The foreperson will retain possession of these records, including the verdict, and return them to the courtroom. The foreperson will see that your discussions are orderly and that each juror has the opportunity to discuss the case and to cast his or her vote. Otherwise, the authority of the foreperson is the same as any other juror. Until your verdict is announced in open court, you are not to disclose to anyone else the status of your deliberations or the nature of your verdict. Your initial conduct upon entering the jury room is a matter of importance. It is not wise to immediately express a determination to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position even if you later decide you are wrong. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement, if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender an honest conviction in order to be congenial or to reach a verdict solely because of the opinion of others. In order to return a verdict, it is necessary that all jurors agree. Your verdict must be unanimous. Your verdict must be based solely on the evidence and on all the law as the court has given to you in these instructions. Nothing that the court has said or done is intended to suggest what your verdict should be. That is entirely for you to decide. If you have any question or request during your deliberations, your foreperson should write that question or request on a paper and notify the bailiff so that the question or request can be delivered to me. The court cautions you, however, with regard to any message or question you might send, that you should not reveal your numerical division at the time or the status of your deliberations. It should be reduced to writing so that there will be no misunderstanding as to what you request. It should then be delivered to the bailiff, who will submit it to the court. Whenever all 12 jurors agree upon a verdict, you will sign the verdict in ink and advise the bailiff by using the buzzer in the jury room. You will then be returned to the courtroom. As mentioned earlier, you have heard all the evidence. It is common practice when jurors commence deliberation and request transcripts of various witnesses. There are no transcripts. Juror number 11, you were selected to serve in the event of any misfortune to any member of the panel. At this point, you will no longer accompany the jury to the jury room or participate in deliberations unless directed by the court. Please remain in the courthouse until the court directs you. It will not be necessary for you to serve any further. You are not to discuss this case or tell anyone how you would have voted until after the jury has returned a verdict. After you are discharged, you may discuss your verdict and your deliberations with others, but you are not required to do so. You must decide for yourself whether or not you will discuss such matters. It is the lawyer's duty to protect your desire not to talk about the case, if that is your decision. It is improper and unethical for a lawyer or anyone else to harass, entice, or exert improper influence on you for the purpose of getting you to talk about the case. Once 12 members of the jury have agreed to a verdict on each of the counts and have signed the corresponding verdict forms, the foreperson will notify the bailiff and you will be returned to the courtroom. Anything further from the state?
No, Your Honor,
From
thank
the
you very much.
defense?
Not on behalf of Mr. Jackson.
All right, you may now begin your deliberations.
All right, jurors, if all of you want to back into the juror number 11.
All right, anything else for the record from the state?
No, Your Honor.
Defense?
No, Your Honor.
All right.
Oh. Go say something, go ahead. You sure? No, I can't go that way.
Push it up.
She needs to make it 29.
Alright, there's nothing in here, right, it's just this, right? Right, this is
That was the
this.
other, yeah, that one. Yeah, that's
Yeah,
going there,
this
just so that it wouldn't get
Okay,
misplaced.
okay,
Everything else should be up there.
okay.
That's right, I can walk back into chambers. There isn't anyone else. Involved with the jury, and I don't know where Maria is.
What's the matter?
I didn't renew the Rule 29.
Okay, here, I'll get it.
Thank you.
Yeah, with her too, especially like very close, and she was like locked in. Like, how do they choose the just randomly?
No, it was our last person. He just seated her in the middle, so she didn't think she was the alternate.
Oh, she was in the middle.
Yeah. So,
They all go back
We're gonna do
for
this
deliberations,
when-
but they do have to stay, just in case somebody has.
when they
like,
go,
blood,
they're gonna be,
just
he'll want to
blood.
be around the area, so just be with it. I mean, you don't have to sit sit at our office if you want to. You can go grab something to eat.
I have a feeling
To the station. You can go to our office or you can go grab something to eat. Just be within 3 to 5 minutes from here.
You said you don't need to because there was no evidence.
I'll be relatively close.
Okay.
Okay, I just wanted to make sure.
The verdict forms in writing, okay?
Oh, is it with the, is it in here? Is it with this one?
It's his instruction.
I didn't know this is what the judge gave me. No words? Okay.
You know what, they might be up on the bench there.
Oh, wait, did I forget it?
They might be still up here. Yeah, they're up there.
So Bob, just stay close,
I would say, how close does the judge generally want people?
You can go to back to your offices and take lunch, do whatever you need to do.
Are they gonna?
And I'll just call everybody when,
Or are they gonna stay?
I don't know yet what they're gonna do yet.
Yeah, 'cause I
They haven't told me yet. They're
Okay.
trying to decide as to whether they're gonna have lunch or not.
Lunch,
But,
you guys are close, aren't you?
but I can give you
great for me. I love it. So I can't, I can't do this.
Try not to separate in on the sun. We'll see. Or we'll just
Bring an umbrella. Just a regular umbrella. You can put it over your head.
then she'll be like, it'll become a huge toy and anything could happen.
But yeah, their house was beautiful. It was like a log cabin, they had it on like a lake.
Oh, nice. No, they were, I mean, he was a year younger,
Gotcha.
maybe 2. They played soccer. I remember that. Because my friend Shannon Craigmont was in their grade, and she was the first female. She had a female soccer team. She was the first female to play soccer at Madison. She played with them, I think. She's a principal in Madison. Madison, South Elementary. The only thing I remember about them is that they had a lot of hair and freckles.
Sure did.
That's it. That's all I remember about them.
They still do.
Who did Doug marry?
Heidi.
Gina?
No,
Okay.
Heidi.
Hmm.
Well, okay, I take that back. One of them married a Heidi. You can't really know his name. Because they both like moved like further away, so they stopped like coming around the family gatherings all the time.
I thought one of them married this girl, Gina Leone, who looks a lot like Nina Ricci.
They might have, but I don't think so. I can look into it.
Hmm.
Because I mean, they're on my wedding.
Could've sworn.
They're on my wedding list. Yeah, they might have.
Okay.
Because like I said, the one just stopped coming around. Brad or Doug, and I always get confused. I don't remember.
Yeah, and I never knew them apart, so.
seated, please. All right, has the jury reached a verdict? All right, would you hand it to Bob, please? All right, in the case captured State of Ohio versus Mark Jackson Jr., 25 CR 59. On count one, strangulation, we the jury being duly impaneled and sworn find the defendant Mark Jackson Jr. guilty of strangulation as charged in the indictment, dated July 29, 2025, signed by all 12 jurors. First additional finding to count one, we the jury find the state did prove beyond a reasonable doubt that the alleged victim was a family or household member of the defendant, dated July 29, 2025, signed by all 12 jurors. Second additional finding to count one, we the jury find the state did prove beyond a reasonable doubt that the alleged victim was a person with whom the defendant was or had been in a dating relationship, signed July 29, 2025, signed by all 12 jurors. Third additional finding to count one, we the jury find the state did prove beyond a reasonable doubt that the defendant was previously convicted of a felony offense of violence, dated July 29, 2025, signed by all 12 jurors. Count two, domestic violence. We, the jury, being duly impaneled and sworn, find the defendant Mark Jackson Jr. guilty of domestic violence as charged in the indictment, signed July 29, 2025, signed by all 12 jurors. Additional finding to count two, we, the jury, find the state did prove beyond a reasonable doubt that the defendant was previously convicted of domestic violence, dated July 29, 2025, signed by all 12 jurors. Does either side wish to have the jury polled?
No, Your Honor.
We would, Your Honor.
Yes?
Yes.
All right. Ladies and gentlemen, I will identify you by jury number and ask you if this is your verdict, and you can reply. Juror number one, is this your verdict?
Yes, it is.
Juror number two, is this your verdict?
Yes, it is.
Juror number three, is this your verdict?
Yes.
Juror number four, is this your verdict?
Yes.
Juror number five, is this your verdict?
Yes.
Juror number six, is this your verdict?
Yes.
Juror number seven, is this your verdict?
Yes.
Juror number eight, is this your verdict?
Yes.
Juror number nine, is this your verdict?
Yes.
Juror number 10, is this your verdict?
Yes.
Juror number 12, is this your verdict?
Yes.
And juror number 13, is this your verdict?
Yes.
All right, ladies and gentlemen, thank you very much. If you go back to the jury room, I'll be back to talk to you in a couple minutes.
All right, so jury.
All right, have a seat. All right, I'm going to refer this for a pre-sentence report and a psychological evaluation and a victim impact statement. Sentencing will be September 5 at 10 a.m. and I'm going to revoke the bond. Anything else from the state,
No, Your Honor, thank
from
you.
the defense?
Not this time, Your Honor.
All right, we're adjourned.
All rise. September 10 o'clock.
10 o'clock? Okay, I can write that, thank you.
What?
You wanna stay or you wanna go? It's up to you either way. You can go ahead and leave.
I'm going.
Taylor.
Josh, you looked